Consumer Protection Laws, the Future of Trinidad and Tobago, Moving Toward Fair Digital Finance by Mr. Rudyard Davidson of the Trinidad and Tobago Cybersecurity Incident Response Team. Mr. Davidson is an attorney at law, admitted to practice in Trinidad and Tobago, having been called to the bar in Trinidad and Tobago in 2000 and in Illinois, USA in 1995. He has represented a range of clients in both the public and private sectors, including the government of Trinidad and Tobago. He currently serves as the Executive Legal Advisor, Information and Communications Technology in the Ministry of Digital Transformation, and has previously served as Head of Legal, Policy Research and Strategic Services in the Office of the Prime Minister, as well as Head of Legal at the Ministry of Public Administration and Information. In addition to his undergraduate degrees in chemical engineering, petroleum engineering, and law, he is the holder of a Master of Laws in Corporate Commercial Law from the University of the West Indies, a Master of Business Administration from the University of Chicago, a Master of Science in Chemical Engineering from the University of Houston, and a Legal Education Certificate from the Hugh Wooding Law School. He has also successfully completed a project management certification course, advanced negotiation, mediation, and arbitration courses, and a procurement evaluation and decision methodology course. He is the principal of Davidson and Partners, which focuses specifically on advising corporate and individual clients on legal transactional matters, corporate governance, and regulatory compliance in business operations. Mr. Davidson has previously served as the chairman of the National Heritage Committee, which drafted and operationalized a national policy for the management, conservation, and commercialization of heritage assets in this country. He was also a member of an IDB team which advised on building institutional capacity and developing an implementation framework and budget for a public-private partnership coordination unit in Trinidad and Tobago. Mr. Rudyard Davidson, our final presenter this evening.
Thank you very much, Madam Chair, for the very kind words. My colleague, Ms. Sonia Guian, and myself are very pleased to be able to address you on the Data Protection Act and the extent to which that act can enable digital finance. And in so doing, and before I get into the meat of the presentation, it would be remiss of me if I did not bring greetings from our Minister, Senator the Honorable, our Minister, and Senator the Honorable Hassel Bacchus, who, as many of us know, is Tobago born and bred and has a particular passion for digital transformation. And so we are excited, as I indicated, to speak to you on some of the initiatives, including a particular legislative framework, which we believe is going to enable digital finance to occur, as the Chief Secretary would have indicated, fairly, inclusively, and safely. Allow me now to share my screen with you. So we at Digital Transformation consider that it is built on three pillars: digital society, digital economy, and the digital government. Digital society we would have seen spoken about earlier this afternoon by our presenters. And it involves the citizens of our great island nation, or twin island nation, actually being digitally literate, being able to perform digital transactions seamlessly, and Trinidad and Tobago being a digitally literate country. We are also interested in digital economy, in which ICT not only plays an important part in the conduct of business, but also it accounts for a significant percentage of our GDP. And we always talk about moving away from a concentration in oil and gas and diversification. Digital economy is certainly one of the ways in which we can move rapidly to achieving that goal. And the third pillar is one of digital government. And Here we contemplate provision of services digitally or electronically by the government, delivery and consumption of government services electronically on a day-to-day basis. So the digital transformation work, the framework, actually is enabled by three key pieces of legislation. The first of which, and which will be the subject of our discussion this afternoon, will be the Data Protection Act. The second of which is the Electronic Transactions Act. And I mentioned to you that the Data Protection Act and the Electronic Transactions Act are companion pieces of legislation that were both passed in the year 2011. And those two pieces of legislation, which work hand in hand, are what, in my humble estimation, now enable the kinds of digital finance and other types of digital commerce that we are accustomed to today and that we are going to be able to delve into and take more full advantage of going forward. But those enabling pieces of legislation require an infrastructure of enforcement. In other words, the Data Protection Act and the Electronic Transactions Act, those two acts are enabling. So they provide rights, they provide conditions. One provides any safety and security of personal data. The other one provides the equivalence of electronic records, electronic transactions, electronic signatures. However, to ensure that those rights are enforced, to ensure that those rights can actually be availed by both the citizens, businesses, and the government where necessary, we must have that enforcement piece of legislation. And that is in the form of cybercrime legislation, which will be coming to a parliament near you in the very near future. So the problem, quite simply, is that we have increased digitalization, we have increased digital commerce, and increased digital finance. And what does that mean? It means that there's been a rapid expansion, an explosion, if you will, in digital flows. And all of this, therefore, causes a significant risk to data privacy. The solution, we need robust data protection legislation because that provides both the framework as well as the enabling mechanism for digital finance and digital commerce. And it does so via enhanced data privacy protection. So let's get into e-legislation or data legislation. And such legislation is fundamental, as I noted, to realizing our goals or pillars of a digital society, digital economy, and digital government. Because what it embodies is a harmonized body of legislation that authorizes, enables, and empowers three things, one of which is the subject of our discourse today: digital finance. It also empowers and authorizes the facilitation of business, digital business, otherwise known as e-commerce or e-business. And finally, it facilitates government's delivery of its products and services, known as digital government. So let's talk about data protection as one of the key pillars in digital legislation. And we wanted to discuss it under three thematic areas. We want to look at the objectives of the act, we want to look at the existing framework, and then we want to look at the enforcement scheme. So it is governing legislation for data privacy, and it protects the personal data of both public and private bodies. The object, quite clearly, as stated in the act, is we want to keep an individual's right to privacy private. So we want to enable you, or the legislation seeks to enable you to keep your private life private and personal. And the reason why the Act seeks to do that is because you have this fundamental human right. At 4C of the Constitution, it says that Every individual has the right to respect for his private and family life. So the Data Protection Act is entirely consistent with your constitutional right. Now, personal information is very broadly defined. So let's look at that existing framework of what it is, and then we will look at what it is not. So obvious candidates will be race, nationality, ethnic origin, your medical history, as Mr. Beach had been discussing, as well as Mr. Keep, your financial and financial transaction information. Importantly, your address, telephone number, or name. That is also personal information. And the likely candidates of your DNA and fingerprints, etc. But here is what it is not. In the context of a public body, so here we're looking at whether it's the division, or we're looking at the THA, or we're looking at central government, the fact that you're an employee or a public official is not personal information. Similarly, your business telephone number, your business address is not personal information. And if you were to author a professional opinion in the course of your employment, that also is not personal information, and neither is your name on such document. Sensitive personal information, however, and the Act accords a very special place to that, and I will treat with that in a more detailed fashion as we move through our presentation. That involves personal information of a more particular nature, and personal information that could be subject to abuse. So, for instance, your racial or ethnic origin, your political affiliation, believe it or not, your religious beliefs, clearly your mental or physical health, your sexual orientation, and even your financial record. All of these are considered sensitive personal information. And as we will see, sensitive personal information requires increased safeguards and protection in terms of the fact that processing them, not just disclosing them, but processing them requires consent or other authorization of law. Now let's look at the operationalization of the Data Protection Act. Regrettably, the Act has not yet been fully proclaimed. However, what has been fully proclaimed are the following. Part 1, which would be the general privacy principles, and we will get into the specifics of that because they have particular impact and implications for the business that we do in both public and private organizations on a day-to-day basis. Part 2 has also been, or parts of Part 2 have also been proclaimed, that is to say, the establishment of the Office of the Information Commissioner. And Part 3 in relation to obligations that public bodies must observe in order to disclose information. The disclosure has to be consistent with the purpose that the information is collected, or any use consistent with that purpose. Now to the general privacy principles of Part 1 of the Data Protection Act. Notably, those principles are applicable to all persons. So not just the government, but the private sector as well. All organizations who are what we call data controllers. That is to say, they store or handle or process data of individuals. In other words, data belonging to some other person. So the first principle, which is a somewhat obvious principle, is that a data controller or an organization is responsible for the personal information under its control. Accountability. A second important principle is that when information is collected, whoever is collecting it must identify the purpose for which it is being collected, either beforehand or at the time of collection. The knowledge and consent. You would have heard our speakers talk about informed consent in order to make informed choices. Well, an individual's knowledge and consent must be obtained for the collection or disclosure of his personal information. And similarly, when personal information is collected, there must be some legal basis for it to be done. And that legal basis must be restricted to what is necessary for the purpose for which it is collected. We talk now about retention. We retain personal information only for as long as it's necessary to achieve the purpose. So that, whereas in the past, we used to think that we can maintain the data of persons ad infinitum, those days are beyond us, they are behind us. Those days are long gone. We must retain data only for as long as it's necessary for the purpose for which you collected it. And then we must systematically engage in what we call data destruction. That is to say that that data must no longer be accessible because it would have served its purpose. We want individuals to have the ability to correct their personal information. Nobody wants to have information held by the government or held by the bank that is not complete or up to date or is simply inaccurate. And we want to make sure that your information is protected by the appropriate safeguards. And as I indicated earlier, we want to make sure that we do not process your sensitive personal information unless some law authorizes it. Now, this is very important for organizations, and indeed all of the organizations represented here. And that is to say, you are required to make available to any person who may so ask some statement of your policies and practices as to how you manage personal information. So you have to have that written down. What is your policy regarding management of personal information? So tomorrow, I'm sorry to have to do this, Chief Secretary, but tomorrow somebody could come up to any of the divisions and say, I want to see what this division's policy on personal information is. And it would be good if upon so being asked, the relevant official in the division could pull out that policy and produce it to the person and discuss it as well. So we also give to the individuals the opportunity to challenge whether an organization is complying with the general privacy principles. So for instance, an employee of central government, an employee of the bank, an employee of any organization can challenge whether that organization is complying with the general privacy principles. And in fact, as we will see later on, there are implications for such non-compliance. If your personal information is to go outside of the jurisdiction, so my friend from the bank earlier would have talked about a particular payment gateway that was used by his bank. Well, to the extent that such payment gateway or facilitator requires that personal information leave the jurisdiction of Trinidad and Tobago, then the data controller who owns or who has control over that personal data has to ensure that that foreign jurisdiction in which that particular, in this particular case, that particular bank sits, so that the processor of information sits, that they have comparable safeguards to those that we possess in Trinidad and Tobago. So whenever data is going to leave our shores to go elsewhere, we have to first ensure that such comparable safeguards exist. Now let's talk about some policy considerations. Our digital legislation, just as we've described, including data protection, electronic transactions. You would have heard my colleague talk about EFT, electronic funds transfer regulations, cybersecurity legislation, etc. They are based on certain principles: open government and open data. Open government is a term that we all would be familiar with because we have been moving for some time towards transparency and accountability, and the whole notion of citizen engagement. And with open data, in a similar way, we want to make the data more available to the public. That also facilitates increased transparency, but it also promotes increased economic opportunity and, in the final analysis, more effective government. Our days of secrecy, aided and abetted by the Freedom of Information Act, I might add, our days of secrecy are unnumbered. And as a matter of policy as well, I should point out that even though the act has been partially proclaimed, it is still expected that all organizations, both public and private, must follow the general privacy principles. So that from a consumer standpoint, and tonight we are discussing consumer digital finance, consumers have the right to have their information not be disclosed, as I indicated, without their informed consent, and to have their personal information only be collected for a specific purpose or use consistent with that purpose. So those particular principles are in fact good law, because those sections of the Act have been proclaimed. And therefore, those principles are required to be followed. We turn now to the Office of the Information Commission, because Part 2 of the Act would have established the Office of the Information Commission. And the Information Commissioner is the regulator of data privacy and data protection. So the Commissioner is therefore responsible to monitor compliance with the Act, to perform audits. And as I would have indicated to you, where any particular individual finds that an organization is not complying with the Data Protection Act, he can file a complaint with the Commission. If he seeks to correct his personal data, which is a right that he has, and that organization refuses his request, he can also file an appeal to the Commission. So I want us to keep in mind those two prongs of what we call jurisprudence that the Commissioner enjoys. That is to say, he can adjudicate complaints made to him by concerned individuals. He can also adjudicate appeals by persons whose right was directly affected in that they were unable to correct or to obtain their own personal data. And upon such an appeal or complaint, the Commissioner, just like a judicial officer or tribunal, can either affirm the decision of the public body, order that the information be corrected to the extent that it was a request to correct. If the complaint was frivolous, dismiss it. Or if an organization was found to be non-compliant with the general privacy principles or code of conduct, he can order the organization to so comply. Allow me to quickly point out as well, in relation to codes of conduct, that the Data Protection Act has what we call, or embodies, a co-regulatory approach when it comes to the private sector. That is to say, whereas with the public sector, it has a rather strict compliance regime, with regard to the private sector, it enables the private sector to develop what's called voluntary codes of conduct. Once such codes of conduct are developed, however, the expectation and the requirement is that such organizations must act in accordance with those codes. However, in the exercise of his discretion, the Commissioner can determine that mandatory codes of conduct are required for certain sectors of our economy. And where a sector regulator exists for such sectors, for instance, the central bank as the financial services regulator, or the telecommunications authority as the telecoms regulator, it may require that that regulator oversee the development of the code of conduct. So the main takeaway from this is that once such a commissioner has been appointed, he or she will ensure that data privacy will be protected, so in a way to facilitate consumer digital finance. In other words, to facilitate digital business, to facilitate digital commerce, and thus, in so doing, ensuring that we can take our place as a country internationally, along with our peers and along with developed countries, in ensuring that we have protected flows of data. Now, as we move towards the end, we must say something about the enforcement scheme, because we need to understand that, you know, there are implications and risks for non-compliance. Please do not obstruct the commissioner or any of his officers in that board. You do that and you commit an offense. If you contravene the whistleblowing provisions, because the Act has whistleblowing provisions that say that if a person, an employee, files a complaint to the commissioner about the non-compliance of his or her organization with the Act or with the general privacy principles, he or she must face no repercussions for that, no negative repercussions. The typical whistleblowing provision. So if you contravene that as an employer, then you would commit an offense. There are confidentiality obligations under the Act, wherein the commissioner or any other staff in doing an audit, if they are privy to any information, they must keep it confidential. Breach any of these and an offense is committed. And what of the fines? What are the actual penalties? For persons, for individual persons, on a summary conviction, in other words, a conviction in a summary court, what used to be called a magistrate's court, now called a district court, the fine is $50,000 or imprisonment for a term of 3 years. And if you are indicted, therefore in the assizes or before the High Court, the fine is $100,000 or imprisonment for not more than 5 years. Now, if you are a body corporate, an organization, and you commit an offense, you see what the regime of the penalties are, significantly high, up to $500,000 if you are indicted and convicted. But there's also a framework of administrative penalties where a court can impose up to 10% of your annual revenues or your annual turnover where the corporation contravenes the Act. And what is the court going to look at? What was the economic cost of your breaking the law or contravening the Act? How did that impact on consumers? What benefit did you as the organization derive in breaking the law? So it is ensuring that breaking the law does not pay. So that is where the court now has the power to impose, in addition to the criminal fines and penalties we saw, administrative penalties, hurting an organization in the pocketbook where it does not comply with the data protection laws. So in conclusion, we have seen that data privacy is a necessary expedient for digitalization. Data flows are only going to flow seamlessly, will only be expanded. We will only be able to facilitate digital commerce if individuals and organizations believe that their personal data is exactly that, private and personal. So safety, security, and integrity of data is required for digital finance. And the relevant legislation we've looked at, the Data Protection Act, provides both the framework for such data privacy protection, as well as an enabler of the digital commerce and digital finance, which we are seeking to further. So my message in ending is that the solution to our problem, to our conundrum, is the data protection. Thank you so much, ladies and gentlemen, and we'll be happy, Ms. Gian and myself, to entertain any questions in our panel discussion.